Hi, I'm Jeff Giunta with Fleit Intellectual Property Law. In this brief discussion, I'll be looking at what it takes to have an invention be patentable, and we'll discuss what examiners will compare an invention to determine whether it is patentable. In order to receive a patent, one must prepare and file a non-provisional patent application with the U.S. Patent and Trademark Office. These applications are examined by patent examiners to determine whether the invention meets the requirements for patentability. Among the requirements for patentability is that the invention be considered new and non-obvious. In making the determination, the patent examiners are limited to looking at only certain types of information. The patent statute defines materials that can be considered to determine whether an invention is patentable. The patent statute allows looking at patents and published patent applications. Also, any published printed publication from anywhere in the world can be considered. The publication has to be verified to have been published before the earliest filing date of the patent application being considered, but if it qualifies, it will be considered as a reference that can be used to determine whether an invention is patentable. Examining these publications, patents or patent application publications, allows the examiner to determine what the knowledge in the field was at the time that the inventor filed a patent application, and whether it would have been obvious for someone of ordinary skill in the art, is the term used to describe the person, whether such a person could just combine knowledge that was already in the field in an obvious way to create the invention that's being considered to be patented. If existing information could be obviously combined to create the invention, then the invention in the application will not be considered patentable. In addition to this background knowledge, if you will, the examiner can also look at evidence that an invention or a product incorporating the invention was on sale or otherwise available to the public. This is not so much a matter of whether the information was available to allow someone to create the invention. This is really a public policy matter where you don't want people selling products for a while and then filing a patent application to have an extended monopoly on the product. The information about the product, the technical information that would be required to create the invention, does not have to be public knowledge for the on-sale bar to take effect. Just the fact that you try to sell the product that included the invention is enough. In the U.S., other countries do not have this grace period, but in the U.S. there is a grace period of 1 year before you file a patent application to do the things that are listed above, such as have a printed publication or have an on-sale offer or otherwise make an invention available to the public. You have 1 year after you do that for the first time to file a patent application. If someone else does it, you do not have that grace period. That would preclude your invention be considered patentable as of the time the other person publishes information or offers something for sale with the invention. You have the 1 year grace period if it's your publication or your offer for sale. We mentioned new and non-obvious was the standard. At the end of the day, there's not that much difference between them. Saying an invention is new means that one publication does not describe it. That implies that one publication would describe your complete invention as is, and it wouldn't take anything for someone to extend beyond what one publication disclosed to achieve your invention. Non-obvious means that it wouldn't be obvious for someone to take knowledge that was already in existence, combine it together in an obvious way to create your invention. An invention has to have both of these qualities to be patentable, but if the examiner is saying that it was obvious to combine things to achieve your invention, it's easier to argue that it would not have been obvious, or not everything was in the prior teachings, and there are other arguments that can be used to convince the examiner that the invention is non-obvious and thus should be subject to a issued patent. I certainly hope this was a helpful introduction to what makes an invention patentable. I wish you the best of luck in commercializing your invention or idea. And if you need further information, please contact us via our website, fleitip.com, for a free consultation. Hi, I'm Jeff Giunta with Fleit Intellectual Property Law. In this brief discussion, I'll be looking at what it takes to have an invention be patentable, and we'll discuss what